Welcome to MrNBT channel. As part of AIPA, All India Practicing Advocates training sessions, we'll be having the session on case types, jurisdiction, relief, court fees calculation by an practicing advocate for the advocates. Please go through entire video to capture the subject matter, and also at the end of the session you will have an effective question and answer section answered by our practicing advocates. Please subscribe the channel if you are coming for the first time to this channel. Enjoy your practice section.
Okay, so case types, jurisdiction, relief, court fee calculation. These four topics are very basics before entering the court. Okay, before entering the court means whenever we are to take the cases, right? So we have to understand what is the case type and where we have to file the case, and a client is what is expecting the relief from the court, and how we can calculate the court fee and how we can pay the fee to the court. So these are the very basic things when you file the case. Okay. So for example, everyone aware, right? We have major two types of case types. One is civil and criminal, but sometimes, right, we can also consider the family as a one type of case type. But most of the things, family will fall under civil and criminal. So broadly, we have only civil and criminal in general. So civil means whenever we have any disputes between the persons, okay, and if you have any a breach of contract, breach of trust, okay, and performance of specific relief, declaration of a title, recovery of possession, okay. So all these types are comes under a civil category. Coming to criminal, so criminal category, we have a lot of things when it involves the criminal nature. So for example, we have a different types of criminal cases. For example, we have assault. We already know, right? Some of the topics we already learned in IPC. Assault, battery, robbery, murder, and cheating, rape, mischief, sedition, criminal conspiracy. Okay, these all comes under criminal nature. So we have to file these type of criminal nature cases in criminal courts only. Okay, so we have two types of courts as well, civil courts and criminal courts. Sometimes only in city areas. Okay, in city areas they are categorized for family courts as well, based on that amount of cases. Okay, mostly we can see the family courts in city areas like Hyderabad or some major cities. But other district courts, right, we don't have any separate family courts. Only senior civil judge or district court will take the family matters. Okay, only metropolitan cities, we judge high courts or state level high courts has the power to categorize the family courts and establish the family courts. Okay, so here, for example, we are saying a civil courts. Metropolitan cities, we judge high courts or state level high courts has the power to categorize the family courts and establish the family courts. Okay, so here, for example, we are saying a civil courts, right? So can anyone tell me what type of cases we can file, as part of civil?
Like land disputes, okay, like land disputes which will come under civil, and between the families, like family related, like property issues and these things also we can file in civil.
Okay.
And
Motor
Like
Vehicle Act.
motor vehicle act also will come under civil, correct? And other thing is like if some diverse cases and these things also will come under civil if it is not in family court. Okay,
Okay.
that is what. Yeah, if anything is there, you can add for that. Yeah.
Yeah. So mostly we can see under civil category, civil cases category, most of the cases as of now, more than 50% of cases are a dispute between the two properties which are related to the property. Okay. And we can say property related disputes. Okay. And the recovery of money. Okay. We can see NI cases, check bounce cases. Okay. So check bounce cases is sometimes it's a criminal nature also. Okay. Most of the things is a criminal nature, but sometimes if you don't have any criminal nature, then it falls under a tort kind of thing. It is a involve more both civil and criminal nature. Okay. And recovery of possession, declaration of title. You have some agricultural property. Okay. We already learned. You have a 2 floors building. So 2 floors of buildings they're destroyed. Okay. Some of the amount you already used, right? Due to that intervention. So you can file injunction, permanent injunction to not enter that person to your property again or to restrict, as well as you already done some damage to your property. So in that case, we can parallelly, we can also in the same shoot, we have to file another IA, but we will discuss later. But we have to file another IA in the same case, and we have to file damage of that property. Okay. So mostly in civil, right, we can get only compensation reliefs, specific reliefs. Okay. But whenever we are going to criminal, we don't get any compensation. We will get, so the courts will provide only punishments. Even in criminal cases, right, if you get any compensation, that compensation will not provide to you. The state will take that compensation. And coming to family matters, so family matters is a combination of both civil and criminal. Sometimes like 498A, divorce, child custody. Okay, so all these types of some is a mix of civil and criminal nature. So like divorce, child custody, and sometimes child support, maintenance, alimony, and domestic violence. So all these types of family matters comes into this category. We have separate courts for family based on the area of the city. Say, so as of now, coming to in Telangana, we have only family courts in separately formed family courts in Hyderabad. But in other areas, district level, only already we have senior civil judge or junior civil judge or junior civil judge, senior civil judge, and district courts will take family matters based on subject matter. Okay. Coming to civil, right, we have, I mean, if you open that e-court services app, right, we can see a lot of case types like original sheet, OS, okay, and double P, writ petition, and double PA, writ petition appeal, and CRLP, okay, and CMP, and HMOP, MBC. So we can see all these type of case types categories. Okay. So based on that subject matter and the relief and the jurisdiction, right, the case will be number given by the court. Okay. Coming to the jurisdiction is a very, very, very important. Okay. We have 5 types of jurisdictions. One is original jurisdiction, appellate jurisdiction, subject matter jurisdiction, pecuniary jurisdiction, and another one is so I haven't added, but a territorial jurisdiction. A jurisdiction will decide where we have to file the case, whether it is High Court, Supreme Court, or junior civil court, or senior civil court, or district court, or any other than these courts. Right, we have another tribunals also. Tribunals, ACB court, okay, excise court, income tax tribunal, So we have a lot of tribunals based on we have administrative act, right? So based on administrative act, right, for every department, most of the department, they already formed the tribunals to reduce the burden on the courts. So the motto of that administrative tribunals is to reduce the burden on the court. Why? Because they are the subject related matters. For example, income tax related, right? So income tax related means the most of the things are related to income tax. Okay, so other people, whenever that comes into the court, right, so other than that arbitration tribunal, higher authority people, they have a more grip and the control on the subject, so that they can easily solve that disputes between the income tax related things. Okay, so that's why we have a lot of NCLT, National Commission Law Tribunal. Whenever there are any company related disputes, right, they will go to NCLT, appellate tribunal. We have base level jurisdiction as well as related appellate tribunals as well. Okay, so coming to, I will detailedly explain what is original jurisdiction. So original jurisdiction, mostly Supreme Court has the power. Sometimes High Court also has the original jurisdiction power. I will tell you. For example, sometimes, right, we may see center and state related disputes. Okay, for example, Government of India and the Telangana and Andhra Pradesh, right? So here, one central government is involved and two states are involved. Okay, so in that case, in Telangana level we have a court, and Andhra Pradesh level we have a court. Okay, so in that case, right, the case should go to Supreme Court. That is the original jurisdiction. So we have other scenarios also when the case will go to original jurisdiction. For example, sometimes some of the people can file case on elections, right? President election or prime minister elections, right? So in that time, we have to go to Supreme Court only, because Supreme Court has the original jurisdiction on that matters. So how we can file the case in Supreme Court? So we have Article 32. Article 32 has the original jurisdiction power. So based on that Article 32, right, so they can issue certain direction to the concerned departments. Okay, we know we already have some types of writ petitions, right? So mostly they will file a writ petition to get the relief. Mandamus, quo warranto, habeas corpus, certiorari, provision. So this type, based on that category, right? So they will file the writ petition on the Supreme Court under Article 32. Similarly, I will tell you another scenario why I'm telling sometimes High Courts also has the original jurisdiction. Okay, for example, sometimes, right, a district to district. Okay, I will tell you one scenario. Now, recently one case happened in Andhra Pradesh, right? So in Jagan earlier ex-CM, right? So someone filed a case in Supreme Court and asked to transfer the case from Andhra Pradesh High Court to Telangana High Court. Okay, so here two states are involved, right? So in that case, High Court does not have a original jurisdiction. Only Supreme Court has the jurisdiction to transfer the case. Okay, here two states involved. Okay, so the higher authority is Supreme Court only. So Supreme Court has a power to transfer the case if that is petitioner, whatever he mentioned the point, right? If it's satisfied, then Supreme Court has a power to transfer the case. So sometimes state high courts also has the original jurisdiction. Okay, I will tell you one scenario. For example, someone filed a case in Mahabub Nagar district court. Okay, so the petitioner, okay, you file and generally in a civil court we have a petitioner and a defendant, right? So petitioner, so just assume in Mahabub district court I have filed a civil case, okay, but in district judge is my relative. Just assume is my relative or well-known person to me. So in that case, right, defendant can file a petition in High Court. So whenever he filed a case, that petition in High Court, right? So they will tell all these points. Manohar is a he has a jurisdiction to file a case in Mavnar only. I agree, but in that court, who has a judge already sitting judge is a relative of the Manohar. Okay, so obviously, right, he may favor to something, he can favor to me, right? So in that case, right, the defendant can file a petition in a High Court. So in that case, my case can be transferred to the nearest another district court. Okay, maybe Rangareddy district court, or it will be transferred in this scenario because within the High Court jurisdictions we are requesting to transfer. Okay, for example, Mahabub Nagar district court and Rangareddy district court, these two courts falls under High Court jurisdiction. So High Court jurisdiction has a authority and power to transfer the case to another district court. Okay, so this is one scenario. We are talking about high district court level. Even if you have a low level juniors, for example, junior civil, you can take the same scenario. I have filed a case in Mavnavar junior civil judge court. Okay, so in that case, right, so even defendant also can file a case in not district court, High Court only appellate transfer related cases, right? Whenever the case transfer intentionally, that time only High Court and Supreme Court has the power. There's no district court does not have this kind of power. Okay, this is the original jurisdiction. Coming to appellate jurisdiction, so for example, we have a hierarchy of the courts, right? The base level is junior, just assume junior civil judge, and on top of we have senior civil judge, and on top of we have district judge, on top of we have High Court, and on top of we have Supreme Court. Okay, for example, I filed a case in junior civil judge Mahabub Nagar. Okay, the case is disposed and the judgment is in favor to me. Okay, so the aggrieved party, in this case, right, the defendant. So defendant can file an appeal in district court. That is first appeal. He can file a first appeal in district court, Mahabub Nagar district court. Okay, then once the decision is come, right, so then even after that, the aggrieved party can file a appeal in High Court, Telangana High Court. So that will be a second appeal. This is one flow from base level. If you file directly in a district court, okay, the judgment came, right? So aggrieved party can file a appeal in High Court only. That will be a first appeal. Okay, so here, right, how we can decide that for junior civil court and district court or senior civil judge court, right? That will comes under subject matter. I will tell you that how it is. And sometimes, right, we can directly file a writ petition. Sometimes we will file a writ petition or appeals in only in High Court, right, or Supreme Court also. But just assume I have filed a writ petition in High Court. Okay, so the decision given by the honorable court. So the aggrieved party, where they can file in Supreme Court only. Okay, so This is appellate jurisdiction and subject matter jurisdiction. So subject matter jurisdiction is very, very important. So because the subject matter will decide based on nature of the case and subject matter.
Sir, excuse me, sir.
Hmm.
Sir, bill on which organization we can file, sir? Bills.
So any organization generally, right, a pill is a different concept,
Sir.
but mostly NGOs, right, non-profit organizations we have. So mostly those people, and any person also they can file. But
Yes, sir, on educational institutions we can file bill, sir.
We can file. We can file, but the motto of the pill is only the motto of pill is,
sir,
it should be impact to the majority of the people, not
yes.
If it is individual, for example, due to education institution, right?
Yes, sir.
Only I'm not getting the scholarship. Okay.
Sir.
In that case, I have to file a writ petition because it is a private right. It's violating the private my individual right only.
Okay, sir.
So in that case, we have to file a writ petition, and then based on the decision, I can get relief, but not others. Okay.
Okay.
Sometimes, right? Sometimes the judge will take consideration, and sometimes the WP also can convert to pill.
For the welfare of the people, can we file against them?
We can file.
Suppose
the subject matter is important, and that should be some impact to the huge people.
Sir.
And it should not involve the individual rights.
Many private organizations and schools and colleges, they are harassing the employees and they are not giving more facilities to them, and they are not at all considering their welfare and all, sir. That's why.
Okay.
I want to know, in these cases, can we file a bill against them?
See, again, we can file, but right, the judge has a discretionary power.
Okay.
Okay. If it is really, it is, if you convince the judge, right, then the case will be taken and they will give the number to you. The case will be taken and they will provide a pill number.
Sir, the present educational institutions are treating employees as laborers. That is the main problem, sir.
And one more, just remember one point. The first step, it should not be the court. For example, in generally, because the most of the cases, right, the judge will ask this question. For example, I have a land, okay, 1 acre of land.
Sir.
So the MRO is not giving the passbook to me.
Okay.
In that case, right, I should not go to directly the court.
Yes, sir.
First, we have one administration department, right?
Yeah, of course.
We have to file up. I have to file an application in MRO office.
Yes.
Okay. We have to give that proof also. Whenever you are filing a case, right? We have to provide these proofs. I already approached to MRO office, and that MRO office is MRO person is not intentionally giving the passbook to me due to these reasons. Okay. And the final step should be court. Just remember.
Okay.
Even in your case also, you are saying the teachers are not getting benefits from that, right? So
yes,
we have a district level. If it is a district level, we have a department.
Yes, sir.
District education officer. We have education officer or some persons. We have authorized administrative persons, and that too we have a tribunals for that specific matters. So we have to go to that category only.
Okay, sir.
Not get any relief, then we have to file attach that everything, your application and what is their response. If you're not satisfied, right, then gather all the evidences and you have to file the writ petition in High Court.
Okay. First, we should approach the.
My name is Prashant, sir. Sir, I would like to ask if
subject matter jurisdiction, right? So subject matter jurisdiction will decide based on nature of case and subject matter. For example, if it is civil related matter, okay, then obviously it will go to junior civil judge court or senior civil judge court or district court. But if it is a criminal nature, okay, if it is a criminal nature, then it will go to uh, uh, metropolitan court or assistant sessions court or sessions court. So indirectly sessions court, nothing but it is a classification of criminal nature cases it will take. And district judge means the judge will be same, but he will hold the district judge and magistrate post as well as sessions judge. Okay. Similarly, the senior civil judge will take the matters of criminal as well as civil cases. Okay. So the senior civil judge we can call whenever it is comes to a criminal nature, right? So we can call assistant sessions judge. Okay. So the subject matter jurisdiction based on the matter of whether it is a criminal, then it will go to sessions judge, okay, assistant sessions judge, metropolitan courts, mobile courts, it will go. If it is a criminal civil nature, then it will go to junior civil judge, senior civil judge, district judge. Okay. And for example, I will tell you here, the point is very important. For example, I have a 1 acre of land. Okay. So someone is intentionally encroaching my property. Okay. So I want to file civil suit in the court. My property valuation is, okay, just assume 35 lakhs. The scenario one is 35 lakhs. Okay. So in that case, where I have to file the case, just assume the jurisdiction will comes under Mahbub Nagar junior civil judge or senior civil judge or district judge. Okay. So here we have a subject matter. Okay. For example, my property valuation is 35 lakhs. So whenever, right, based on subject matter and that amount value, right, so the court will be taken care. For example, the property valuation is below 20 lakhs, then obviously that we have to file that case in junior civil judge court. If the property value is 20 lakhs to 50 lakhs, then we have to file the case in senior civil judge. If the property value is more than 50 lakhs, then we have to file that civil suit in district court. Okay. So here, see, they have a certain limitations. The property value is 50 lakhs. Just assume the property value is 60 lakhs. If you file a case in junior civil judge court, because that junior civil judge does not have a subject matter for that specific case, because he has authority to take the cases up to 20 lakhs only. But here the property valuation is 50 lakhs, 60 lakhs in our scenario. Even if you get a judgment, right, there is no use, because there is no authority to provide the judgment on that matter. Okay, that is very important. Subject matter is very important. And one more thing, the family court. Okay, whenever we are going to divorce. Okay, so divorce, right? So obviously the senior civil judge will also act as family judge. Whenever a divorce, maintenance, all kind of things, right, we have to file the case in senior civil judge. And we have one more thing also. For example, whenever you are filing a partition suit, okay, so partition suit, whether irrespective of property valuation, for example, the two persons, okay, one father is there, they have that person has 4 childs, okay, 2 sons, 2 sisters. They want to file a partition suit between the parties. Okay, the scenario one is the property valuation is 10 lakhs. Even the property valuation is 10 lakhs, generally, we already discussed, right? If the property valuation is 10 lakhs, generally it should go to junior civil court. But that junior civil judge does not have a subject matter jurisdiction. He cannot deal partition suits. Partition suit always should go to district court. Only district court, district judge has a subject matter jurisdiction to solve on partition suits. Okay, so this is subject matter jurisdiction, and parallelly, based on subject matter jurisdictions, right? Lot of tribunals was formed. You remember, right? I mean, before Dharani, we have tribunal, land tribunal, right? Whenever we have a land related issues, right? Generally, we'll go to that land tribunal. And income tax related issues, electricity related issues, election related issues, and company related issues, we have NCLT. And income tax related issues, we have electricity board. On top of that, we have electricity board appellate tribunal also. For income tax, we have income tax tribunal. And parallelly, we have on top of that, if agreed party, right? If agreed party not satisfied that decision of that income tax tribunal, then you can, on top of that, we have income tax appellate tribunal also. So there they can appeal. So we have separate tribunal, they can handle the issues. For example, I have got a notice from, just assume I got a notice from income tax department. Even though I have paid entire tax, I got a notice from income tax department. So in that case, right, I cannot go to this junior civil court and senior civil court and district court. I cannot go. I have to go to that income tax tribunal only, because the income tax related matter jurisdiction, right? Only that income tax tribunal only, they can solve that income tax related matters. And coming to pecuniary jurisdiction, so pecuniary jurisdiction, right? For example, based on pecuniary jurisdiction, we have a small cause cases. If the amount is less than 500 rupees, right? Mostly it is rent related or money, some money related, right? So those cases we can file in small cause case court. So the small cause case mostly in metropolitan cities. If it is not metropolitan cities, then we have to file in junior civil court. So mostly pecuniary will decide based on the money value. For example, if you have any agreements, you have given some amount to the party. If the value is more than 10 lakhs, right, we have to file a case in district court only. Mostly this is related to breach of contract. Okay. And whenever we are filing a plaint copy, right, what relief you are expecting from the court? I given some of the reliefs, but we have a lot of reliefs under Telangana Court Fee Valuation Act as well as Court Fee Valuation Act. Okay, we have central level act as well as state level act. For example, relief is very important in civil suits. Okay, for example, I have a property and someone intentionally encroaches the property. So I want to relief from the court. In that case, whenever we are filing that suit, right, indirectly plaintiff. So generally in the plaintiff, we have to write everything, cause of action, what are the actions on so and so dates and everything we have to mention, right? So there we have to mention all these details and what relief you are expecting from the court. So based on that relief, we have to pay the court fee. For example, I have mentioned here declaration of title. Okay, for declaration of title, based on the valuation of the property, we have some amount. We have perpetual injection. Perpetual injection, nothing but permanent injection. So someone is in, you are in a position, okay, the property is in your control only, but someone is intentionally sometimes, right, they are coming and they're doing some unnecessary activities. So in that case, right, so we can file perpetual injection to not enter that persons to your property, right? Then we can get a relief from the court. For that perpetual injection, right, we have to pay some amount. So based on that relief, the court fee will be vary. So recovery of possession, I have 1 acre of land. Okay, someone is occupied that encroached and already that person is staying in that land. Okay, but actual owner is, that land is mine. So whenever I am entering that property, those people are intentionally enforcing. So that time, right, we have to file a recovery of possession. So court, if the decision is right, if the arguments and everything complete, right, the court will give the decision. So later, right, if judgment is unfavor to you, right, so we can file execution petition and we can request to the court. So court will give the direction to the department, maybe police department, right? The police people will go to that position and they will vacate the things, and the property will be handed over to you if you file execution petition. So the relief is very important whenever we are filing the suit. For example, recovery of money. Okay. So for example, X person has given 10 lakhs to Y person. They have all the documents, everything documented. We have a promissory note and they already written an agreement. Okay. And the limitation also falls under 3 years, because if it is a agreement, right, a contract or agreement, the limitation should be 3 years. If cross 3 years, then that is not enforceable by law. The limitation is over. But always we have a condonation delay, even if the limitation is over, but the final discretion power is taken by the judge only, whether it is accept or not accept. So these are the most reliefs. We have a lot of reliefs actually. I will show that. And court fee calculation. Okay. So in civil, whenever we are filing civil suits, hello? Whenever we have filed civil suit, right, the court fee will be based on property valuation only. Okay. So because we have to mention all the property valuation and everything in the plaint. So how we can calculate the fee?
As per government, sir?
Yes, as per government.
Government value. Market value of the government.
Yes.
Okay.
So we have 2 acts. I will show that. Okay, we see the Telangana Court Fees and Shoots Valuation Act 1956. Actually, it was the Andhra Pradesh Court Fees and Shoot Valuation Act 1956. Okay, this was renamed through government order GO. Okay, so here if you see, these are all this is a state level act, the Telangana Court Fees and Shoot Valuation Act 1956. Whenever we are calculating the fee, right, we have to go through this act and we have to calculate. But if anything is not present here, right, then we have to take this act. This is a central act, the Court Fees Act 1870. Okay, this is central act. But always generally we'll go through the state act. If not found any related court fee valuation, right, then we have to go to central act. That is Court Fees Act 1870. I will go through this one relief and how we can calculate the court fee. I will show you. So under this Telangana Valuation Act, right? So the court fee valuations are available in Schedule 1 and Schedule 2. I will show one thing how we can calculate. If you see here, the petition issued under the Converts Marriage Dissolution Act. If you are filing any petition related to this, right, the court fee is 10 rupees. For Muslim also is 10 rupees. Okay. If it is petition under the Indian Divorce Act, excluding petitions under Section 44 of Act and every memorandum of appeal under Section 55. So Indian Divorce Act will apply if the spouses are related to different communities. Then the Indian Divorce Act will apply. So that time we have to pay 30 rupees. I will show that money recovery. So this is the point number 6 is very normal. Okay, generally, for example, we already got the judgment. Okay, the case is already disposed. If you want to take the judgment copy, right? So we have to pay 1 rupee court fee. I will show money recovery where it is. Do you know what, when we are filing the writ petition in High Court, what is the court fee? 100 rupees. If you file bill, right, then it will be 10 rupees. Now, if you see here, just we'll take that application to set aside an award under Section 34 of the Arbitration and Conciliation Act. So the arbitration tribunal already given the judgment, their order, right? But whenever we are approaching to High Court, that amount, if the amount is less than 1 lakh, then we have to pay 200 rupees to as a court fee. If the amount falls under 1 lakh to 5 lakhs, right, then we have to pay 500 rupees as a court fee. And where the value in between 5 lakhs to 10 lakhs, 5 lakhs to 1 crore, then we have to pay 1000 rupees. Where the value exceeds 1 crore, then we have to pay 2000 rupees. Like that, we have a valuation. If you see here, the option O, petition to the High Court for the admission of an advocate, attorney or vakil. Okay, generally, whenever we are filing the wakalat, right, behalf of a plaintiff or a defendant, we have to pay 20 rupees as a court fee. I think in first page only. If you see here, right, even that court valuation also, sometimes they will mention the subject matter and jurisdiction also. If you see the plaint or written statement pleading a set of or counterclaim, do you know what is the set of and counterclaim? Okay, both are different matters. In any suit of the nature cognizable by courts or small causes, when the amount or value of the subject matter does not exceed 500 rupees, if the suit is actually filed and tried as a small cause suit. Okay, so if we have certain limits, 100 to does not exceed 100 rupees the valuation, right, then 49 paisa, and if it is between 100 to 500 rupees, then 89 paisa. Like that, we have a court fee. Okay, I will share these two documents, so just to go through, so that we can understand how the things.
Okay, okay, sir.
Sir, I would like to ask if PIL can be filed against a private organization, sir. Thank
Okay,
you, sir.
we can file. Okay, we can file, no problem. But there's it should impact the huge number. If it is impact to you only, then you have to file a writ petition, not appeal. Appeal also is a type of petition only. But the intention is right, that the violation is happening to huge numbers, right? Then we have to file appeal.
Thank you, sir. Sir, can you also please, sometime, if possible, explain about the petitions we present in the courts? Like, I mean, not just this petition, any other. You're talking about EP, IP, IA. written statement, let other some procedures.
Yeah, that topics will come in a next.
Thank
okay?
you, sir.
Yeah.
Thank you, sir.
Sir, partition suit can we file in family court or only district court, sir?
Which case?
Partition suit.
Partition should we can file only district court.
Not family court.
Because it's a subject matter. Even if
Okay.
file, right, if any defendant or plaintiff will object that, then it will be transferred to district court.
Okay. So in family court, only family matters, means wife and husband. The disputes between wife and husband. Then only we can go to family court.
Yes.
Okay.
Not only process, it may involve also maintenance, child custody, child support.
No, sir. Child support, maintenance.
Parents maintenance also.
Yes.
So all these matters also comes under family.
Adultery also comes under family court, sir.
Adultery is a part of one part of divorce.
It's part of divorce. Okay, sir.
Sir, good afternoon, sir. My name is Prabhakar, sir. Hello.
Yeah, tell me.
Sir, the small doubt about this notary properties. The notary properties can be claimed from the civil court only, right? Do you have any other jurisdiction for this notary properties? Like,
the notary property means that is falls under civil category only. So mostly that notary related things will property related, right? We have to file in civil court only. But again, right, already told, right? So if the property valuation is below 20 lakhs, right, then we have to file in a JCJ.
yeah. Okay, got it, sir. Thank you.
That we have to file.
Okay, sir. Thank you, sir.
Hello, sir.
Yes, please.
Sir, this is Pawan from Bangalore.
Yeah, tell me.
Sir, నేను తెలుగులో క్వశ్చన్ అడగొచ్చా? అంటే కొంచెం కంఫర్టబుల్ గా ఉంటుంది. మీరు ఇంగ్లీష్ లో ఆన్సర్ చేయండి, నేను కొంచెం తెలుగులో అడిగేస్తాను. నాకు కొంచెం యాక్చువల్లీ నాకు సివిల్ కేసెస్ గురించి డౌట్ ఉంది సార్. నేను ఏబి ఎగ్జామ్ కంప్లీట్ చేశాను కానీ ఇంకా ప్రాక్టీస్ స్టార్ట్ చేయలేదు. నాకు జూనియర్ ఒక అబ్బాయి ఉన్నాడు, వాళ్ళు 3 తరాలుగా ఒక కేసు గురించి వాళ్ళ ఇంటి గురించి కోర్టుకు పారాడుతున్నారంట. ఇప్పుడు రేపు మనం కూడా అడ్వకేట్ అయిన తర్వాత ఇలాంటి కేసెస్ మాకు వస్తాయి కాబట్టి నేను అడుగుతాం అనుకున్నా, సివిల్ కేసెస్ ని మనం త్వరగా కంప్లీట్ చేసే ఆప్షన్స్ ఏం ఉండదా సార్?
See, that is completely depends on advocate only. Okay. That is advocacy knowledge. That is completely dependent on advocate.
Sir.
So he has to create some urgency and then he had to take temporary relief. As I told, right, IA. They have to file a IA.
Okay.
Interim application and have to get some relief from that court. Even if it is 15 years, 20 years, right? At least if you get a IA, temporary injection or temporary relief from the court, not to enter that person's, then what is the loss to you, right? They will not enter the property. You are in the position, then use, right? So that's why I clearly told initially itself, we have to claim proper relief to the court. Then only we will get the judgments and all those things accordingly.
అంటే సార్, ఇప్పుడు ఇద్దరు పార్టీస్ సివిల్ కోర్టుకి వెళ్ళారంటే, నా ల్యాండ్ లో ఇంకొకరు వచ్చారని, ఒకళ్ళ దగ్గర ఖచ్చితంగా అన్ని డాక్యుమెంట్స్ క్లియర్ గా ఉంటాయి, ఇంకొకళ్ళ దగ్గర డాక్యుమెంట్స్ ఉండకపోవచ్చు. నార్మల్ గా ఇప్పుడు ఎవరైనా కబ్జా లాంటివి ఏమైనా జరిగినప్పుడు ఒకళ్ళ దగ్గర ఖచ్చితంగా అన్ని ప్రాపర్టీ డీటెయిల్స్ కానీ వాళ్ళ పేపర్స్ కానీ రికార్డ్స్ అన్ని ఉంటాయి. అయినా కానీ సమ్ టైమ్స్ ఇట్స్ టేక్ 10 years 20 years కదా. అది నాకు డౌట్ యాక్చువల్గా. ఇలాంటి సిచ్యువేషన్స్ ఎలా చేయాలి సార్? అంటే అవతల పార్టీతో ఏం లేనన్నప్పుడు మనం ఎలా మూవ్ చేయొచ్చు?
అది depends on advocate something. Process lame undadu change. Process is common to every advocate, but how the advocate is reacting and how the advocate is claiming this type of things from the court, right? That is the matter.
బట్ నేనే అడ్వకేట్ అయితే నేను దీన్ని 1 year 2 year లో క్లియర్ చేసే ఛాన్సెస్ ఉంటుందా సార్? ఇన్ సివిల్ కోర్ట్ లో అన్ని పేపర్స్ నా దగ్గర పక్కాగా ఉన్నాయి అన్నప్పుడు
We can, but at the end, right, you have to get that kind of knowledge.
Okay.
What relief you have to claim, and what is the procedure, and the arguments, cross examination, chief examination, re-examination. We have a lot of examination types, right? So we have to ask proper questions in the examination.
Okay.
And that leading questions, right? That leading questions will mostly decide the case. That leading questions can be formed in cross examination only. Okay, you can ask these type of questions. That property, that person is claiming that property, right, at the defendant. So in that case, right, why you are going to that property? Do you have any documents, and what are the documents? These types of cross examination. How you got that property? What is the link document? Where is link document? So these type of cross examination, cross questions we can ask in cross examination, so that all the points will come into the argument category. Then the judge can understand this person does not have any legal authority and the legal documentation also. So then, right, that time you can file IA and we can get the relief from the court. So that is depends on advocate only.
Okay, sir. అర్థమైంది. Thank you, sir.
The judicial process is common for everyone, but how you are applying and how you are convincing the judge, that is the matter.
Okay, sir. Thank you, sir.
Okay. Good afternoon, sir.
Yes.
Good afternoon, sir. Hello.
Yes. Please tell me.
Sir, my question is, what is the limitation period for filing a case?
See, that's why,
civil-
right, we have a separate act for that, limitation act. Okay. So if
Okay.
it is contract agreement related things, right, so obviously the limitation is 3 years.
Mhm.
If it is, you already got a judgment, and for example, you got a judgment on 2024 2012 you got a judgment. Okay.
Okay.
So now you want to file a execution petition.
Hmm.
If you want to file execution petition on that judgment, right, the limitation is 12 years. If it is 12 years is crossed, right, you cannot file a judgment. I mean, you can file a execution petition on that. You cannot request a court to implement that judgment. For that, the limitation is 12 years. So similarly, whenever we have, for example, you have one plot, okay, that open plot. So you transfer that property to another person through sale deed. Okay.
Okay.
Later, right, your son came enter and that person asked, right, why you transfer that property to that person. So if any objection from your son side, right, then he can claim that he can file a suit within 12 years, because the limitation is 12 years for the sale deeds and all these things. For contract agreements, these are 3 years. For execution petition is 12 years. If any partition and that kind of thing, right, that is 30 years.
How many years, sir? 13?
30 years. 30.
Okay.
For that, right, everything we have a limitation.
Sir, then what about the domestic violence and other thing? For domestic violence, I heard there is no limitation period or something, even for the dowry.
No, for that we don't have any limitation.
Sir, sorry for the interrupt. One more question. As a fresh case, they did not file a case for a few years, but later they want to file a case. What is the limitation period? Due to lack of knowledge, sir. So they don't file case. Maybe after 40 years. who can file, sir, after 40 years?
See, in that case, right, still you can file a case, but right,
Okay.
scrutiny every case, whenever you file a case, right, the scrutiny
Okay.
will happen. In the scrutiny process, they will check the limitation and everything.
Okay.
If the limitation is crossed, right, first of all, they will not take the case. They will not number your case. And even if you request that person, even if you register the case, obviously that will go to, even the number is registered, and now it is coming to hearing something, right? So even that case also, judge will raise a concern. The limitation is, or judge will raise a concern, or opposite party, they will raise a concern. The limitation is over, then your case will be dismissed.
There is no exceptions.
No exception, but still we have some limitation. I mean, that condonation. See, always we have a provision, condonation delay. Condonation delay, we can use that condonation delay. But for example, I will tell you, I have, for example, X person given 50 lakhs to Y person. Okay.
No.
The limitation, generally, that is a contract. The people are executed promissory note and everything. But unfortunately, the X person got coma. I mean, he was in coma from last 3 years. Just assume, okay? The limitation is over, but after the X came out of from coma, and now he realized I have given some 50 lakhs to that Y person. Okay.
Yeah. Okay, sir.
And he asked, actually, he X go to Y home, and he asked the money, 50 lakhs. Y said, the limitation is over. You cannot do anything. You can go to the court. So here, even the limitation, we know the limitation here, already 3 years is crossed, but still this X has a valid reason that from last 3 years, he is in coma.
Yes, sir.
He can file a condonation delay petition whenever he is filing the case. So in a scrutiny time, right, they will check that limitation period is over. So there he can check the medical bills and everything. Okay.
Yes, sir.
So then they will consider the case through condonation delay.
Yes, understood.
They will take. So that's why the condonation delay, right? If you have a proper reason and anything, right, then even the limitation is over. But at the end, the judge has a discretionary power to consider the case. If judge is satisfied, even if you tell, right, this person is last 3 years is in coma, then even judge also don't have to reject that case. He should accept. So we have to convince accordingly. We have to provide the facts, everything in front of judge, so that we will get a proper relief from the court.
Thank you, sir. Thank you so much.
Sir, good afternoon, sir. This is Prabhakar, sir.
Yes.
Sir, one person has done this agreement of sale and notarized. But he has not completed that agreement, not has done the sale deed. So as per the agreement of sale, you have said the limitation is only 3 years.
Yes.
But that agreement has been notarized. So it comes under the Limitation Act?
No. Recently,
No.
Supreme Court has given the judgment.
Okay.
Notary people does not have any right.
Okay.
Okay. I think 2 years back, we got a judgment from the Supreme Court.
Okay.
Notary people, not authorized persons.
Okay, sir.
Okay. Even if you have a notary, there is no use.
Okay. 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 But but though still we can
see, we can
have a
case, and you can tell the reasons, and you can file a condonation delay.
Okay.
Once the case is registered, then you can proceed these points. We can get a relief. Okay, but generally, Supreme Court has considered this notarization thing.
Okay. Sir, thank you, sir.
Yeah,
Hello,
yeah,
sir.
Manohar. Good evening.
Hello, sir.
Actually, this is Suresh. Hello.
Hello.
Yes,
Hello,
yeah.
sir.
Yeah, this is Suresh calling from Kadapa. Actually, there are three brothers. Okay, and three brothers. Like mother has did a will, and will has also registered 1989. Okay, about some property. But three sons, among the three sons, only one son got this will, and she got registered. That was registered also. Now, his mother was expired. Okay, and now he is claiming that that properties belongs to him. But in between, one of his brother has taken a registration from other brother, means other his brother. Among themselves only they have taken, but the mother has not done anything. Whether this will is enforced and the property will come to only the person who got that will registered. Did you
Okay.
get my question?
Yeah, I got your question.
Yeah.
Was first that mother has a legal authority to give the will.
Yes, she has given a will and registered also in 89 itself on one son.
Okay. On that will, these two other brothers already signed on the document.
No, nobody has done, but only mother has did that. Will has written and signed.
That mother is still alive.
No, she did. She expired.
Okay. Then it is comes under testamentary will. Okay.
Mhm.
So these people can challenge, the other two people can challenge
Okay.
in the court,
Mhm.
and they may get relief.
But in that will, she has written clearly because this son is taking care of her. So on the basis of that only, she has given this property to that son, and she has given full authority and all these things she has written in that that registered will. Even though other two brothers will get.
Okay, you said other two brothers also internally perform the transaction, right?
Only one brother has performed the transaction.
Okay.
There are three brothers. Among three, only small one got registered will on that particular property,
Okay.
and remaining that two brothers, only one brother, his portion he got registered by one brother, and other one has not done anything, no registration, nothing. So anyway, that third person will not get, but the middle person who has registered that, he can get it, or even he can challenge because his will is registered long back, correct, by
See,
her, by
will,
his mother.
yeah, we have to see the terms and conditions under will. Okay.
Okay.
Then we can conclude whether these two other brothers has a right or legal right or not. Okay, that is based on the conditions under the will.
Even will registered also, they can challenge it?
They can challenge, no problem.
Okay.
They can challenge, but that completely based on
Okay.
the terms and conditions under that.
Mm-hmm.
Sometimes, right, even if it is terms and conditions, even these two other people also has at least some legal right. So mother has some portion of that entire property. That property can given to that younger child. Okay. For
Okay.
example, 10 acres of land. So these three people, right? So they individually the entire 10 acres, right? So as per Hindu Succession Act, 2 acres of land can get by mother, and other just assume 2 acres by these three people. Okay. Only those 2 acres can transfer to any person based on that willingness.
Okay.
But so see, at the end, right, that is completely depends on the terms and conditions under will and circumstances of the property. So that only this property has that person, or any other properties also have. Okay, if you have the 4 properties, only this property given to that younger child, right? Then it will be some complicated to prove that. But these people has only one property, and the entire property given to the younger, then we can challenge and we can get the relief.
Okay. Okay.
Hmm.
Okay. Thanks, Manohar.
one question, sir. Now, usually you see the some lands like it's like the owner do the notary, and later on the people who buy the land, they it was before 2019 they could have get registered the notary land, and that registered land the other people also now sell it as a registered land. Does it be challenged or what it will be? You got my question?
Can you tell me again?
So basically, one particular land, big land is there. So what the builders used to do before, instead of doing the registry, they used to sell it in a notarized form. So once they have sold it to notarized, before 2019, they used to get it registered. You know, before 2019, the land, notarized land were easily registered. Now it's banned. So anyone who bought a land, like the notarized one, they converted into registry. Now the guy who got the registry, he's selling the land as a registry only. Does these can be get challenged or not?
We can challenge.
Who who the pattedar can challenge, or
Patedar can challenge.
if he wants to, if apart.
Okay. So we'll continue the things in next session. Okay. Thank you all.
Sir, hello, sir. Hello, sir.
Thank you. Thank you very much, man.
Hello, sir.
Yeah. Thank you,
Can you
Manavar.
share the PDF, sir?
Thanks for watching the video. Please comment how do you feel the session, and also you can give us suggestions in the comments saying that which kind of topics needs to be addressed for a practicing advocate, so that we will come up with that kind of sessions and upload it here. Please subscribe the channel if you did not subscribe, and like the video. Thank you.